Hello friends, from today we are starting with chapter 9 of the Indian Evidence Act, and this is the 50th video on it, and our main focus today will be section 118, which says that who may testify, that is, who can act as a witness or who can be considered as a witness. Uh, The chapter itself is of heading of witnesses. Now, a brief overview of what all we are going to study. So, first we will be seeing that who is a competent witness, or how, or whom can we say that he is a competent witness. Then we'll see certain uh, things about competent witness, like whether a child is a competent witness. Then difference between three types of witnesses, that is chance witness, interested witness, and official witness. So let us begin as to the uh, section 118, who may testify. Now this section states, section 118 provides that all persons are competent to testify. So all persons, so first of all it says that everyone, like you can see in the picture, everyone is competent witness as per section 118, but unless in the opinion of the court there are two qualifications which have been put. One is that he is unable to understand the questions put to him, that is, if any question is put to him, whether he is able to understand it or not. And second, is unable to give rational answers to those questions. So answer should be rational. So only two qualifications, if these two qualifications are satisfied, then he is a competent witness. What are those two? First, that he should be capable of understanding the question, and second, he should be able to give rational answers to those questions. Now, what are there are certain conditions which have been prescribed under section 118 regarding it. Now, what are those conditions? So first is that a person may not be able to understand those questions or give rational answers to it because of these four uh, conditions, for which I have made an acronym IDOC, that is, I am a doctor. What are those? First is that I, that is infirmity. So any such cause of same kind, that is any infirmity which makes a person unable to understand the question or give rational answer to it. Then D, that is any disease. So because of some diseases of mind or body, for example, if person is in a coma, then he may not be able to understand the question or give rational answer to it. Then O, that is old age. So extreme old age, when person starts um, leaving his senses or is not generally in senses, then in that case he may not be considered to be a competent witness. Then C, child. So because of tender years, if a person is unable to understand the question and give rational reply. Now an explanation is also added in it. And what it says, what the explanation says that a lunatic is incompetent to testify. So normally a lunatic is incompetent to testify, but in certain cases he is a competent witness, provided he is able to understand the question and give rational answers to it. Now, having understood it, let us see the explanation about child witness. So, a child witness, whether child is a competent witness or not, then child is a competent witness. There is no reason why a child is not to be considered a competent witness, but that child should satisfy two conditions. One, he should be able to understand the questions put, and second, should be able to give rational reply. In Muhammad Sugal versus the King also, it was stated that child is a competent witness if he understands the question put to him and give rational answers. Now, though he may not be able, what about oath? So, whether it's not necessary for the child to be given the oath, whether he understands the oath or he doesn't understands the oath, till he understands that it is that he should speak truth, it is all right. In one case called Nirmal Kumar versus State of UP, it was held that what about corroboration? Normally, it is a rule of prudence. Remember, it is rule of prudence, not law. That is, it is rule of practice that corroboration, certain corroboration of child's evidence is required. In Bhagwan Singh versus the state of MP, the Supreme Court held that evidence of child is required to be evaluated carefully. Yes, in this case, Bhagwan Singh versus State of MP, it was said that the child's witness should be evaluated carefully. Why? Because he is an easy prey of tutoring. He can be easily tutored as to what to be said where. Therefore, the court always looks for adequate corroboration from other evidence to his testimony, that whether he is tutored or not. But remember, as stated in Nirmal Kumar versus State of UP, that this looking for corroboration is not a rule of law, it is only a rule of practice or rule of prudence. Now, let us come to another as to victim of rape. Whether a victim of rape is competent witness or not, then prosecutrix is a competent witness, just like a injured person is a competent witness. Similarly, she is also. In the state of Maharashtra versus CK Jain, it was held that nowhere in the Evidence Act it says that evidence of rape victim cannot be accepted unless and until it is corroborated in material particulars. So there is no necessity of having material corroboration of the statement of victim of rape. Next is chance witness. That chance witness is a person who by coincidence happened to be at the place of occurrence where incident is taking place. So for example, as you can see here, that incident is taking place and by chance these persons are here. So these, by coincidence, who is at the place of crime is said to be a chance witness. Now, his evidence is not to be merely rejected on the ground that he had no reason to be present at the place of occurrence. So, just because the defense says that his evidence is not relevant, why? Because there was no reason for him to be at the place of occurrence. That doesn't mean that his evidence is not to be taken. Next is interested witness. Now, interested witness is a one who is somehow related or interested in seeing that a particular evidence, a particular judgment is given. So, interested witness is a type of partition witness or a witness with certain motive. So, a partition or interested witness is one who is somehow related to the victim of crime or is interested in the accused. So, he may be a friend, a relative, or a servant, and he need a particular type of judgment. Now, in that case, whether merely saying that he is an interested witness will make his evidence inadmissible, then it is said that no, the evidence of interested witness may be taken. However, what the court should do is that court should scrutinize it carefully. It should be scrutinized carefully. So there is no reason to outright reject the evidence of an interested witness. Just in Krishna Pillai versus State of Kerala, it was held that evidence of an interested witness should be scrutinized carefully. However, where such scrutiny establishes reliability, evidence ought not to be rejected. So, evidence need not be rejected only on that ground that the person is a interested witness. Next, last is that of official witness. Now, who is an official witness? Official witness is normally a public servant and he is associated or joined in investigation of an offense. For example, if we go for a trap witness is there or certain persons of raiding party is there, so they become official witness. Now, what about the evidence of official witness, because they may be a type of interested witness? Then in Hazari Lal versus State, it was stated that if evidence of such a witness, that is official witness, is found to be trustworthy, there is no need to seek corroboration. So in case of official witness, if his evidence appears to be trustworthy, then there is no need to seek any corroboration. Let us have a quick review of what all we did. So, section 118, which says that any person who is able to understand question and give rational answer is a competent witness. A person may not be competent witness because of his infirmity, disease, old age, or childhood. Child is a competent witness provided he is able to understand question and give rational answer. However, it is a rule of prudence to seek corroboration. Then victim of a rape is also a competent witness and did not have any corroboration of what she states. Chance witness is a competent witness, and interested witness, he's the evidence should be carefully scrutinized before taken up. And as far as official witness is concerned, then if found trustworthy, there is no need to seek corroboration in that aspect. That's all. Thank you, friends.